The last few people are going to file in here, but otherwise now's a good time to get started. I'm Harrison Newman, and on behalf of the Federalist Society, American Constitution Society, and Government and Public Interest Society, I want to thank all of you for coming here to this event today. We've got a phenomenal program talking about the Office of Legal Counsel and the role that the office plays in executive decision-making. We have a variety of faculty members here who served in the office, and we're lucky to have two of them with us today. Leading the conversation will be Professor Jeff Powell. Professor Powell is a professor of law here at Duke, where he directs our First Amendment clinic and teaches courses on constitutional law. He's also served in a variety of roles in both state and federal government, in addition to academia, including time as Deputy Assistant Attorney General in the Office of Legal Counsel in both the Clinton and Obama administrations. And our featured speaker here today is Professor Walter Dellinger, the Douglas B. Maggs Professor Emeritus of Law here at Duke. Professor Dellinger has also served in a variety of roles in private practice, academia, and federal government, including serving as the Acting Solicitor General of the United States for the October 1996 term of the Supreme Court. For our conversation today, he'll be drawing upon his experience as Assistant Attorney General, that is, the person in charge of the Office of Legal Counsel from 1993 to 1996. And I've abbreviated their biography significantly, but I think now I'm going to turn it over to Professor Powell.
Thank you, Harrison. Walter and I are very grateful to you and to the organizations for sponsoring this. In September of 1789, at the very end of the Judiciary Act of that year, Congress included a single sentence creating the Office of Attorney General. Congress anticipated there would be a part-time job. The AG was supposed to actually make most of his living in private practice and would have no assistance. There wasn't money for a clerk or an office, physical office. And there were only two duties. The Attorney General was to represent the United States in the Supreme Court and to give advice to the President and other high executive officers. Well, the Attorney General in 2019 is a very different office. In 1870, the Department of Justice was created, and so the AG is now the head of a 40,000 plus federal agency. And the AG has many, many responsibilities. The Attorney General remains, by statute and as head of a department by constitutional command as well, the Attorney General remains the primary legal advisor to the President and the heads of the executive departments. By delegation, the Attorney General carries out that statutory and constitutional function primarily through the Office of Legal Counsel, which was created, it was a different name originally, but was created in the early 1930s. And over the course of the next 40 years or so, the Attorneys General delegated more and more responsibility, even in terms of who signs things. So at this point in time, most formal legal opinions of the Department of Justice carrying out these age-old duties are actually signed by the Assistant Attorney General who heads OLC. OLC does a lot of different things. It provides formal advice, formal opinions. Far more often it provides informal advice to people in the White House, to people in other federal agencies. OLC is in charge of reviewing presidential orders and other kinds of executive orders for their form and legality. OLC does the constitutional analysis that is part of what the Justice Department provides Congress for every bill that Congress considers. And the Office of Legal Counsel resolves disputes between executive agencies. The way to sum up the duties, the formal duties of OLC, is to say that it is the voice of the executive branch on legal matters, and as a general rule, when OLC comes to a legal position, unless it's overruled by the Attorney General, or of course, in theory, the President, him or herself, that's the executive branch's position. That's the formal, that's the rule, those are the rules. We have with us today, it's my great honor and privilege to be with my dear friend and my former boss, Walter Dellinger, who was head of OLC and as well as being Solicitor General. And so maybe, Walter, we could start by, I've laid out the formal total of authorities. You tell us the truth. How do the President's various lawyers relate?
Right. Well, first of all, let me thank Jeff. I don't know that I could have undertaken this job without Jeff Powell to come with me and be my brains. Jeff, I remember at the first holiday party of OLC, I introduced, I believe we had the Attorney General there and the Deputy Attorney General. We were the first component of the Department of Justice to have an official song. And I got everybody ready to queue up. And I think they were expecting Beethoven's Seventh Symphony, Fourth Movement. But it was Think by Aretha Franklin, which was the perfect embodiment of what we do. It's the most analytical part of government, and of course, that's why you would want H. Jefferson Powell. In fact, at my farewell party, I said that what I wanted on my gravestone was the statement, "He hired great people." And just at that moment, you may recall, Attorney General Reno appeared in the doorway. And I said, "Come in, Janet. I was just saying, I want my tombstone to say, he worked for great people." But I did. So you want to have a sense of the relationship between the various lawyers for the president. We can put to one side the private lawyers. Eventually, Clinton needed a coterie of private lawyers, and now President Trump has in his own personal lawyers that he has hired, perhaps lawyers in quotes, but he has hired his own personal lawyers, but there are also a significant number of lawyers, 17 I'm told, who've been hired, who I think are there to deal with matters that don't go to the president's personal issues, but go to subpoena of documents, for example, where I think this busload of lawyers is prepared to resist subpoenas. But here's the relationship. For the first 3 months of the Clinton presidency, with my wife, Professor Ann Dellinger, I had worked on all the orders on reproductive rights that the president signed on his second day in office, which was the 20th anniversary of Roe versus Wade. And at that point, it was known that I was certainly going to have a role in the Justice Department, but we had a difficult time getting an Attorney General confirmed. So it was April before I went to the end of April before I went to the Justice Department. So I had been in the White House counsel's office for 3 months. And the head of the White House counsel's office, Bernie Nussbaum, said to me the most striking thing the last day. He said, "Well, this is Walter's going to be going over today. He's going to be, the president's going to the Justice Department to nominate Walter and 2 other assistant attorneys general." And Nussbaum said to me, "Now, Walter, you'll still be coming over here to the White House to our staff meetings," where I had been housed. I said, "Bernie, we had to have dinner tonight because you have a very different idea of the relationship between the Department of Justice and my role as head of OLC, if you think I'm going to be coming to your morning staff meetings." So at dinner that night, I got out 2 napkins, and I said, "I want to show you 2 different views of the organizational chart of the executive branch of the government as it pertains to lawyers. This is your view. This is your view. There's the President of the United States, and under the President is the White House counsel. And then they are the general counsels of all of the departments, like the Department of Defense, Department of State, as a legal advisor to the Secretary, HHS as a general counsel. The Department of Justice has an attorney general, and the OLC head reports to her. So in your view of the executive branch, here you are. There's Bernie up there, right? And there's me down here. My view of the executive branch is there's the President of the United States, and the attorney general reports to him, and she has delegated, by tradition, all of the legal issues to the head of OLC. And then there are all the departments of government, like the Department of Defense and the Department of State and HHS. Oh, and then there is the EOP, which is the Executive Office of the President. And here you are down here, Bernie Nussbaum. So you're here, and here I am, and here you are, okay? So. Did I do that? No. Oh, okay. And that's okay, that's okay. So I can best sum it up in the sense that as to how you would approach a legal issue in those jobs. I thought very seriously about being put forward to the president for White House counsel at the time that Ab Mikva left. And I decided to stay in the Office of Legal Counsel because at least at that time, by the tradition of our office, we actually made the final decision about legal issues. Someone said, why would you want to be a White House counsel? All he does is pace back and forth waiting for Walter's ruling, you know? Our friend who was the lawyer for the National Security Agency told me that, right? Cresco, right? I think the White House counsel is there to interpret matters for the president. I think it's not a joke to think it should be abolished. Former Attorney General Griffin Bell literally thought it should be abolished, with the exception of some lawyers there to make contracts for the people that tended to the Rose Garden, but that a president should get his or her legal advice from the Department of Justice. And I think that's right and feel very strongly about it, having been in both places, having been a lawyer, even for 3 months. Because when you're the White House counsel or on that staff, and the White House counsel is right there upstairs from the president and the Clinton administration next to the First Lady's office, you're surrounded by people that do politics all day long. And all of them come in brand new. The entire professional staff of the White House turns over with the new president. You come in not knowing what the rules are, and you're surrounded by people who are intensely following the news every minute of the hour, so that everybody's worried about what's going to play well in the next 20-minute feed of CNN News. Now, there were people who I think looked ahead to how an issue would play on the evening news. These men were called visionaries in the intensity of the modern White House of either party. In the Department of Justice, you are, I would say, counting the assistant U.S. attorneys, 90% of the Department of Justice does not turn over with a change in presidential administrations. So you have career lawyers to rely upon. And my saving grace was, for a year when Ann was at the FBI and I was spouse following, I spent it as professor in residence, and I got to know the career lawyers who were still there when we were there. You know their names. Doug Leder is still a legend. He was the one I worked most closely with, is now counsel to the House. I knew the career lawyers, and we didn't do any important issue without involving career lawyers. It was very important to have a variety of viewpoints. And we were also situated in circumstances where there is precedent. I didn't simply impose my own views, but we would go back to what Attorney General Robert Jackson did. If it was a war issue, war powers issue, and troops in Greenland before war was declared. And that, and not my own views of war powers, is what we would look to. So I think the ability to make the legal decisions with your mind uncluttered by the intensity of the politics is something you can do a lot better. When I left the White House, I carried my last remaining stuff with me to walk to the Justice Department to have my nomination announced. And I swear, when I got to the Justice Department building, I put my hand on the wall as if I was safe. Because there are rules in the Department of Justice. You know, and the White House I found to be a dangerous place to be working, you know, for one's professional career. But at the Department of Justice, I had the benefit of Jeff Powell and Chris Schrader and a couple of wonderful colleagues of ours. And it gave me the confidence to think that, you know, when we stayed up virtually all night on an issue, that we had really thought it through as well as it could be. And I had, I think, the internal confidence of knowing that our answer was as right could be gotten, you know, given the vagaries of law. So I told Bernie that night, so, you know, here's our different views of the legal arrangement of the executive branch. I'll give you one example of what I thought was appropriate. We had an issue of governmental support of religion. And we reached our settled conclusion, giving it a lot of internal debate within the office, and we reached our conclusion about what the president could and could not do. And I informed the White House of what our decision was going to be. And I got a phone call that night from the deputy White House counsel who wanted to argue with me about our conclusion. And she was an indefatigable arguer. And she would not give up when I told her what our conclusion was. And we kept going on and on and on. I won't tell you who it is. Her initials were Elena Kagan. You know, a formidable argument. But after a couple of hours, I'm exhausted at that point. I said, Elaine, that is our decision. She said, okay, I knew that was where you were going to come out. But I thought the president deserved for me to give it my best shot. So her view is to try to convince us on behalf of the president that he could do what he wanted to do and we should change our opinion. And my job was to try to make the best legal decision. Now, I would differentiate that role from one other legal role, federal district judge. Because I thought at OLC, at least we owed it to the president to try to accomplish some of what the president would like to accomplish. Dawn Johnson, our colleague, always rejected my argument that a tie goes to the president. But I did not think that was inappropriate for the head of OLC in the way it would be inappropriate for a federal district judge. So does that give you a sense of the layout of White House counsel, OLC, president's private lawyers? And we can talk about the Solicitor General later. Yeah. What else you got?
Well, Walter, that all sounds nice and fine, but look, let's talk turkey. You were appointed by the president. You could have been removed by the president. I was appointed by the Attorney General. I could have been removed by the Attorney General. We were political appointees. Isn't the reality that our job was to, in the end, give the president legal cover to, you said we should take into account the president's agenda. No, I'm saying that why isn't it true that our real job is just to create this legal smokescreen behind which the administration gets what it wants? What's the answer?
You know, that is a common assertion, and it is sometimes true of OLC. I think it was true of the torture memos. I think it was a terrible falling from the traditions of the office to do the indefensible memorandum interpreting waterboarding and other techniques as not covered by torture in the statute, and then to construe the statute as unconstitutional if Congress wanted to limit the president in Congress's role making rules and regulations. So I thought it was, but I have told people, I've seen OLC, and you have too, and Jeff knows more about this than any living human being, because he has collected the greatest of the opinions of the attorneys general, which they were opinions of the AG before they were opinions of OLC. There are innumerable instances where OLC stands up to the president. And when I talk about this, I cite examples from the other party of mine. I'm not going to, just talk about my particular virtue, but look at what Ted Olson did, examples, and look in the administration of George H.W. Bush, they thought his election was going to turn on whether they could do something bold that the Wall Street Journal editorial board was demanding, which is to declare that capital gains by statute, by presidential edict, could be indexed for inflation, and to assert that the president had an inherent line item veto power. And OLC said no in the heat of a presidential campaign of Clinton versus Bush. They said no, and they stuck to it. And it didn't happen. And I have seen there were press reports, which I can relate. I was not in the government at the time, and you had left as well, as to whether you could, by statute, give the District of Columbia a voting representative in the House. I thought the better argument, I was not involved in it, was that the constitutional method of election by the people of the state was intended to be exclusive. Congress could do a lot to legislate for the district, but not violate the exclusivity. Well, OLC was reported to have done a 50-page opinion saying that you just can't do it, even though it had been part of the platform on which President Obama campaigned and ran. And they got a ersatz opinion somewhere else in the Department of Justice and indicated they weren't going to accept OLC's opinion. And it was publicly reported that OLC had gotten, quote, rolled, unquote. But you know, it never made it to Congress, because once OLC had ruled, you got a 50-page opinion that Congress is going to want to see. And it devastates the idea. It was dead on arrival. So I think that in that sense, you know, people have their own professional responsibility. You know, people that come to the office, like, you know, if you have someone like Jeff Powell and Chris Schrader working for you, they're going to keep you honest. They're going to go back and have professional, you know, that they want to be authors of an opinion. Their slipshod is a torture memo. They're not going to want to do that. They're going to want to set up. And every president, I swear, I wish I could tell every new president, you are better off with the people that tell you no. And every time a president gets in trouble is when they get the answer they want instead of the best answer. And I saw that in the first 3 months before we had the Office of Legal Counsel set up. And the White House counsel made the decision that the First Lady's Healthcare Task Force did not have to comply with the Federal Advisory Committee Act. Well, the head of that task force almost went to prison because of that wrong opinion that was given in the intense heat of being right in the midst of the most important policy objective. I wonder if I would have had the fortitude to get that issue right if I had worked on it in the White House. I know I wouldn't have gotten it wrong at the Justice Department, because I would have asked the career lawyers. First of all, I would have had you guys. We would have asked the career lawyers. They would have said, you're going to get killed in the district court if you proceed, you know, down that path. I met with every one of my successors and told each of them, look, like many things in life, they'll respect you more in the morning if you tell them no. At least tell them no sometimes.
Walter, let's turn it on its head, though. Why do you suppose that the president and other policymakers actually ever listen to OLC? And I'll give you, you know, you'll remember this well. There was a point in time in 1996 where OLC was asked whether a certain CIA program was lawful or not. And we said, well, we got to think about it, but our immediate thought is probably not. And so this program was shut down while we thought about it. And then when we finished thinking about it, said, well, no, we're actually quite sure it's unlawful. It was shut down till Congress changed the law for good. Why did anybody do that? The policymakers were furious.
They were furious. I was called at 2 in the morning by the general counsel of the CIA, who said they had had a worldwide shutdown of countless programs. Because we said there are circumstances in which U.S. officials can be guilty of aiding and abetting criminal activity, like the criminal violation of the civilian aviation statute and treaty that you can't shoot down civilian aircraft. Colombia and Peru's Air Force were doing that, and we were providing AWACS real-time targeting information to them. And we held that there was potential criminal liability for that. They do other things where they aid and abet someone else who's committing a crime. So the theory of aiding, abetting as applied to that is one that has huge consequences. But, you know, once they've got I'll give you a somewhat simpler example. We had to pass on a method of rendition of people from foreign countries, sometimes without the consent, or at least without the formal consent of the government of those foreign countries. And we went down and met with the Deputy Attorney General, that is our young staff person who came with me. We met with the Deputy Attorney General, and we told her that our conclusion was headed to the notion that they could not use this method of rendition. She and her top people were extremely unhappy with this and let us know their unhappiness. So as we're walking back to the office, the young lawyer says, well, I guess I start all over again on the opinion. it's clear. I said, no, finish it just the way we're doing it. And he says, but that's your boss. You're outranked by the Deputy Attorney General and the Attorney General. And so how could we possibly get away with this opinion? I said, look, you don't understand. The Deputy Attorney General is the action officer on an activity like this. She can't ask for a legal opinion that it's lawful, give a legal opinion that it is in fact unlawful, order the opinion reversed, and then act on that opinion. She know he would be a fool to do that. Once we have come to our opinion, it's a fact about the world. And these are criminal statutes that surround this. They can't. I had to tell them in many instances, you got to remember, you have the final say as a practical matter once you have made your legal opinion and put it in writing. There's nothing they can do. Does that answer that question?
Let me just also say that this is not just Walters in my view. Jack Goldsmith, for example, who was head of OLC under President George W. Bush, has written that from his perspective, it may be that the policymakers are almost too concerned about what the lawyers think. He thinks they sometimes get hidebound by fear about the lawyers. But what that confirms is that policymakers, contrary to what the blogosphere often assumes, policymakers take very seriously what the lawyers say, and I think it's in large measure what Walter says.
Well, remember Jim Comey and Jack Goldsmith.
Oh, yeah.
Jack Goldsmith, now at Harvard, lifelong Republican and head of OLC and the George W. Bush administration, when there was intense pressure coming out of Vice President Cheney's office, right, to allow a method of surveillance of raw data on American citizens, that Jack said, as head of OLC, he meets with the Deputy Attorney General and says, we think this is unlawful. The Deputy Attorney General is going to refuse to sign the authorization, affirmative authorization, to continue this program. The Attorney General, who could overrule them, is in the hospital after surgery, John Ashcroft, and the White House counsel and Bush's counsel, who is actually a character in Veep, Vice, the movie Vice.
Oh, right.
David Addington is a character in Vice. They rush to the Attorney General's hospital room where he's coming out of surgery to get him to overrule Jack Goldsmith and the Deputy Attorney General. And Jack and the Deputy Attorney General get wind of this, and they rush to the hospital room. Very dramatic events. The Deputy Attorney General, you will know of, is Jim Comey. And Jack Goldsmith and Attorney General Ashcroft said, I'm in no position to make this decision. I've transferred my authority to the deputy. His decision is final. And they stood up to him. And I think that's the reason why, you had a deputy AG who was willing to back up Jack Goldsmith's legal analysis, and they could not be overruled by people who knew that they did not want officials who were going to engage in criminal activity, as judged by OLC.
But Walter, even if the OLC lawyers are trying to do their job right, the facts of the matter, the facts on the ground, other than what OLC says, are generally brought to them by the policymakers. So what stops the policymakers from just manipulating OLC?
Chris Schrader and I have actually emailed back and forth about this with regard to the possible declaration of an emergency, giving the president authority he has only in an emergency to transfer funds to border barriers. And I actually think it's one of the hardest questions of how much you push back on the facts that they bring to you. To me, they're easy cases and hard cases. An easy case should have been Travel Ban 1, which was rushed out, done probably by a young Duke graduate, Stephen Miller, in the dark of night. Travel Ban 1 was done. It was the one that led to chaos in the airports, et cetera. They hadn't thought it through. It had not been. They somehow got a form in legality signature out of OLC, but there was no opinion. And there was nothing there for OLC to defer to. There was no interagency process. There was no assessment by Homeland Security. There was no assessment by the Department of Defense. That's why I think they were sure to lose in any court, because there was nothing for a court to defer to and nothing in that instance for OLC to defer to. And that's when Sally Yates, when it was challenged in court as deputy and then acting attorney general, Sally Yates refused to defend it in court and was fired. Travel ban 3, you know, it still arises by apostolic succession from the president's campaign promise to, you know, to prohibit Muslims, all Muslims from entering the country, but they processed the hell out of it by Travel ban 3 that was upheld with, you know, with memorandum from the relevant officials and Homeland and Defense, et cetera. And that gets very hard for, you know, for OLC.
Walter, let's explore that. And let me shift the way we're thinking about it. What kind of questions do you think it's legitimate for OLC to entertain? And let me just make it clear to everybody. I mean, there's a range of possible questions that a policymaker might bring you. What's the right legal answer? Or what's the best argument you can make defending this? Or is there any way to avoid getting us in prison or impeached or something like that? There are any number of range of questions that one might imagine policymakers wanting the answer to. What are the limits, if there are limits, on the questions that the lawyer should answer?
Look, that's a good question. And to narrow it down to 2, what do we think is the right answer and what do we think a court will do, right? And I think it's appropriate for OLC to answer either or both of those questions. I think if either one of them turns negative, the executive branch should not proceed. That is, we could say, you know, we think there's a good chance the court would uphold this, particularly because a court may give a lot of deference to the executive branch judgment. I don't think OLC should give that much deference, not as much as the district judge does. I think you're entitled to be, you have that responsibility. I think you're entitled to be a decision maker to the extent that you can say, I am just not persuaded by the facts on the ground that you don't have a basis for showing me. I mean, I can give you one sort of far less weighty examples than the ones we usually get. There was a very important issue for organized labor, which was companies that bring in permanent replacements for those who go on strike, and therefore the strikers lose their jobs forever. And a big push, first to try to get it through Congress, which was unsuccessful, and then to pressure the administration to issue an executive order barring government contracting with any agency, company, or organization that has a policy of using permanent replacements for strikers, okay? Very draconian as it came to us. And we, in fact, were sufficiently nervous about it because the president can't just issue executive orders without a legal basis underlying the order. There is no freestanding authority to rule by edict or executive order. You have to be facilitating a statutory, usually, or less often a constitutional provision that is the basis for the order. So the basis for this order would be that the president shall promote efficiency and economy in government contracting, says the act of Congress. So I'm thinking, how does it promote efficiency? I mean, if you've got a contract to make combat boots, it may be a terrible thing if the workers go on strike, but doesn't it promote efficiency in government contracting if they'll bring in replacements, right? It seems upside down to me, right, that would promote efficiency to bar that. So I was very skeptical that this was a proper statutory basis for the executive order. We wrestled it. The hardest thing I had politically, you'll appreciate this, was that there was an opinion from the Bush years that the president could, using this very same authority, require the posting on every company's, every room and every company that did contracting with the government, you do not have to join a union, okay? And they upheld that. So I could see myself going into the White House and saying, we don't believe this gives you statutory authority to do this. And they're going to say, well, is there any precedent on that? And I say, yes, there is, but we're overruling it in order to say no. Okay, that's a very tough position for a lawyer, you know, to be in. But I had an opinion from a very senior official of the Department of Labor who had come as a senior political appointee from MIT, one of the leading labor economists in the country, who did an opinion saying that it promotes long-term peace and stability to declare you will never bring in permanent replacements and make them a more efficient contracting partner. It's a theory. And I wasn't a labor econ, so I deferred to it. It wasn't like they just made it up, right? They had a serious guy do a serious opinion. I still thought it the hardest question, closest question I could remember, not by any means the most important. So just to finish that story, so we approved it. It was immediately challenged in court the moment it went into effect by the Chamber of Commerce. It went to the District of Columbia, DC Circuit. The government lost 3-0 in a scathing opinion by Judge Lawrence Silverman about how lawless this was. And then the decision came to go to the Supreme Court to defend it. At that time, I had moved down to be acting Solicitor General. And here's this damn issue back on my desk again. And we got to seek cert in it. And the government, White House already announced that the government's going to appeal. And I said, I do not think we should take this to the Supreme Court because we're going to lose, and we're going to lose we could lose in such a way as that it cripples legitimate future presidential authority to take up a case this shaky, right? And in the dissent from denial of cert, in the dissent from denial of en banc review in the DC Circuit, were Taylor Rogers and no Harry Edwards, the leading labor law expert before he went on the bench. So I thought, this is a message. Don't take this up. Because I said I said, I think we're not going to seek cert. You'll never get away with it. The White House will make you do it. And I said, let me take my chances on that. I'm going to tell them we're not going to do it. But by that time, I'd been in government 4 years, and I had more confidence than I did at the beginning. So I called the Secretary of Labor, who I realized, Robert Reich, had been an assistant to the Solicitor General right out of Harvard Law School. And I met with him, and I said, here's the issue. I think it's a mistake to take it up. Because here's what I'm going to have to argue. I'm going to have to argue this is just as valid an exercise of presidential authority as Lyndon Johnson's Executive Order 11246, which is bars discrimination in government contracting on the basis of the same efficiency provision, right? And if I say to the court, this stands or falls with 11246, Justice Scalia is going to say, where do I sign? You know, we could take down a lot of important programs by foolishly taking this up to the Supreme Court. So Reich says to me, are you telling me I'm supposed to recommend that we don't go to the Supreme Court? I said, of course not. You're the Secretary of Labor in the Democratic administration. Your people are going to file a strong memorandum urging and insisting that we take this to the Supreme Court. I'm going to say no. He says, oh, that works. that works. And so we didn't. We let it lie. But that's just an example of having to deal with other people's facts. And sometimes it's a war powers issue, whether you're in a world in which you can do bombing in Bosnia because of a humanitarian crisis and you've got to assess. It's not your job to assess whether there is a humanitarian crisis, but you need to find that they have a basis for thinking so. You can't just have someone come in and say, there's a crisis, so we're going to bomb Toronto. And you're not to look behind our factual assertion. So you've got to do something. But I think it was Chris that said to me, how hard you push back on the facts is one of the hardest and most uncertain of the tasks at OLC.
Well, since you brought up bombing, let's talk about the fact that when you were nominated to be head of OLC, there were some critics, misguided, But they said the problem with Dellinger is, particularly on foreign affairs and national security, he's going to be the lapdog of Congress. He's going to, really hamper the president in protecting national security. And then a couple years later, different critics were saying, Dellinger is a warmongering, bloodthirsty supporter of an imperial presidency. Did you change your mind, or what happened?
It was very good. It was David Leach who wrote the article that my long-time history of advising Senate Democrats was going to make me a lapdog of the Senate, and I wouldn't be protecting. He's now general counsel of one of my biggest clients, Bank of America. So I called him and said, I'm not going to be a lapdog. I'm going to follow the office's traditions. But when time came for war powers, the Washington Times really went after me. Does where Mr. Dellinger sit determines where he stands? And someone had faxed them comments I made in a floor debate at the Association of American Law Schools at the time of the invasion of Iraq. And they asked would I hold true to my beliefs or whatever. I called the editorial writer and said, that's a great question. That's a very good question. But when we go to decide a legal issue, the starting point is not something I said at the ALS. I said the legal position of the executive branch of the government of the United States should not change if I'm hit by a bus when I ride my bike to work and Jeff Powell takes over as head of the office. You shouldn't change. We start with, as I was saying, with the earlier opinions of the attorneys general and that. So I think it is appropriate that your position is different when you are in an office with an ongoing tradition. We overrule some things. We overruled significant portions of what was known as the Barr Memo done by William P. Barr that asserted the president's authority to ignore acts of Congress to a degree that we thought not consistent with the Constitution. So we do overrule things, but we said in the Dellinger Memorandum, on which you worked so much and so well, that we did believe there was a stare decisis principle in the office.
So what that means is that that Walter wasn't changing his mind. He was reflecting the fact he had different responsibilities, speaking in his own voice on the floor of the ALS, speaking as the Assistant Attorney General for the executive branch with its long-standing legal views.
But to some extent, your views do change, because we had the benefit of meeting with the longtime, sometimes career general counsels for the Joint Chiefs, the Department of Defense, the National Security Agency, and you learn a lot, about, in some instances, the interrelationship between war powers issues in one part of the world and what you're doing in another part of the world, et cetera. So to some extent, your own views are modified by the experience of being in the office and having discussions with people who've dealt with these for a long time.
Can you give us an example of you changing your view clearly?
I think understanding the need for some executive authority about the deployment of armed forces, when that rests upon complex judgments about the state of the world that I would not have appreciated as an outsider, and I do not think the executive branch appreciates, at least when you're trying to stand up to the head of North Korea. If you can imagine an administration where you tried to stand up to the head of North Korea, if that is if North Korea nuclear developments is your number one concern, as it was at points during the Clinton administration, as Secretary Perry said, the use of force in Haiti may be an important part of where you are in your negotiations with North Korea. And I never understood the way in which those issues interacted. You want North Korea to understand your willingness to send troops into Haiti may show your resolve in ways that are important. Is there anything else you made me change my mind on?
Walter and I worked really hard to try to agree, but sometimes we just couldn't. and I always had what I thought was the right solution. I would say, Walter, the Senate confirmed you, it didn't confirm me, so we'll go your way. And you never liked that.
I got furious about that because we had been colleagues for so long. I wanted to wrestle the issue to the ground until we'd resolved it. I didn't want you to say in a fit of pique, well, you're the one that got confirmed, you decide. Like if you want to have that stupid position and the Senate confirmed you, right? That was always the undertone of Jeff. And I wanted to keep going with the argument and not have it end in that manner.
What are a couple of the most exciting or most disappointing things about your experience at OLC?
Disappointing is easy. Jeff pulled an all-nighter on a theory that he and I had in the Romer case, which was a Colorado ordinance that prohibited any agency of the Colorado government from enacting any anti-discrimination laws with respect to LGBT people and issues. And we at OLC could advise the Solicitor General's office, and we wrote an amazing draft that we were going to be able to get by. The Department of Defense was trying to block us from entering these cases because they thought it jeopardized their gains in the military policy. And it was such a simple and beautiful brief, more sharp and clear than Justice Kennedy's opinion, to the same effect that this was one of the first literal equal protection violations you've seen since Yickwo against Hopkins. And we couldn't persuade the SG to file that brief. We couldn't persuade the SG to file a brief in the Rosenberger case. I saw a great opportunity to get the religion issues right by going in a case where you're saying, well, you can do to have government funding of a religious newspaper and things you can't do. We could get away with filing that brief in a case like that. That was disappointing. What pleased me the most, I think, Piscataway. Does anybody just do Piscataway in class? Maggie Lemos's class was talking about Piscataway. It was very similar to strike a replacement. I had the decision that we could not defend when they were down to eliminate one place and they had a white teacher and a black teacher and had shown no particular justification for going to layoffs, and that this was the worst case to take to the Supreme Court on affirmative action issues. And that turned out to be exactly right. The Michigan law school case was a much better case to take up than Piscataway. And everybody thought it was going to be overruled on that. And I met with the president and the vice president and had the good sense to call the heads of every major civil rights organization before I had the meeting to tell them what I had decided and why I had decided it, so that we did not have the blow up that people expected from doing that. I also felt good about the fact that I think we struggled to do the right answer. We really did. I mean, I swear on this stack of Bibles that we would be up till late of the night before writing the opinion, debating what the right answer was, even though we knew what the answer was that the administration wanted. And I think we went through 4 years of that I feel really good about. I think I may have made the wrong call on strike or replacement, but we were trying to get it right. And I think we did that. I think also OLC plays a much more important role than you know from what you see in OLC opinions, because the most important thing OLC does is to say no so firmly that the proposal never sees the light of day. I remember coming back on the fairly long ride from another agency where the Attorney General and I had a 3-hour show and tell with high-tech about a program, and the Attorney General was saying on the way back, that can't be lawful. And I said, it's not lawful if you say it isn't. And she says, well, if you say that, I'm going to back you up. And so we said no to some things. In fact, I have, in subsequent days, times I'll wake up in the night and remember some of those things and realizing that the plans like that they'll have to go to my grave with me as government secrets. Plans like that don't go away. They're in somebody's drawer waiting for a more supine administration to come in. Now, that makes me nervous. I had a good sense of my own shortcomings. I don't have a very good attention span. I have really bad adult ADD. And I'm serious. And I had a fantastic set of deputies, and we had 15 or 20 really great attorney advisors to work with the deputies. We had a principal and a second deputy on every issue to work with the lawyers. And I got to work on 8 different issues a day. For 1 month, I kept notes, by the way. I found my notes from 1 month. I should never have left Washington, but I've got notes. And I counted up. I did 6 to 8 issues every day. And for somebody with a limited attention span, that's great. But I remember the second meeting of the deputies. After the first meeting, and I told many good stories in the first meeting of the deputies, I came in for the second deputies meeting, took my way there, instead of my place at the head of the table was Dawn Johnson. And they all pointed to me at a place down at the end of the table. And they said, "You're not presiding over the meetings anymore." I had a deputy's mutiny. And they were exactly right. They said, "You get to make the final decisions, but Dawn has an agenda that she and Jeff have worked out." and that was great. I mean, I had, it was my highest and best used. Oh, let me just say one more word for people who have to leave, which is why I think it's a better job than being Solicitor General. Ted Olson and I have talked about this. When you're the Solicitor General, you get the wonderful fancy outfit, you argue the cases in a cutaway. It's all, really wonderful, but I'll do it in a little bit of a caricature to make the point clear. When you're the Solicitor General, the question, you can't change the question. By the time it gets to the Supreme Court, the question has been resolved and refined. You could sometimes turn a question a bit on its axis, and once in a blue moon, that could be outcome dispositive. Basically, you know what the question is. And you know what the answer is. The answer is the government should win. The United States should prevail because, and you fill in the blanks of the reasons. And then you have to persuade Anthony Kennedy or whoever, of what the right answer is. At OLC, you get to be, first of all, the final decision maker on these issues. As I've noted, on innumerable issues, you literally can't be overruled. And you get to change the question. You get to say, no, we can't defend. If this is your proposed statute, we can't defend it. But here's something you could do. It's transactional. You could be a transactional lawyer. You can say, here's something different you could do with the program. And you could change the question. And you get to decide what the answer is. And I think in the end, constraining and facilitating, where appropriate, the executive branch, to me, was a much more rewarding job. I talked to both Chief Justice Rehnquist and Justice Scalia, who had the job, and both of them swear, they're not kidding, it was the best legal job they ever had. And they got to be on the Supreme Court.
I agree. Thank you so much, Walter.
Thank you, folks, for coming.